we've been talking a lot recently about the Corporate Transparency Act, which is a new law that went into effect this year on January 1st, requiring almost all small business owners in the United States to file certain reports with the Treasury Department known as FINCEN. I wanted to add a new wrinkle to that discussion, which is a decision from a federal district court in the Northern District of Alabama just a few days ago, holding that the CTA was unconstitutional as it exceeded the authority granted to Congress in the Constitution. So this is a really big decision, and a lot of people have been very unhappy with the requirements of the CTA and are hoping potentially to not have to file those reports based upon this decision. So I wanted to just unpack how the legal process will unfold here. First off, FINCEN has said that they will not enforce the CTA as a result of that decision only against the plaintiffs in that case. So that's a very small class of people who the CTA does not apply to now, given that decision. However, it still applies to everybody else. So you can't rely on that court's decision to say, I'm not going to file. So all of the reporting obligations are still valid law for the rest of the country. Now, what's going to happen next in that case? Well, of course, we don't know exactly, but it's likely that FINCEN will challenge and appeal the decision of the district court, which means that they have 30 days to appeal to the 11th Circuit, which is the federal appellate court above that district court. And then that court will decide whether they want to issue a stay, they'll hear the case on the merits, and they'll make a decision. And then that might ultimately go to the Supreme Court as well down the road. At the same time, there might be other cases that are filed in other jurisdictions as well, challenging the law. Again, those decisions would be decisions that would be applicable to those plaintiffs, again, unless there is a higher court decision which would be more binding. So for now, the case is the case is interesting, but it doesn't actually change the law that is in effect. So you still have to file these reports, again, 90 days for any new formations, and for existing entities, you have until the end of the year. So if you're waiting to see how these cases unfold, you do have some time. Potentially you can file these later in the year unless the law changes. But for the new formations, 90 days is still going to be the rule, so that we were doing them basically concurrently with any formations for all of our new business formations. So hope this is somewhat clarifying. We've been getting questions about, how does this new law impact our reporting obligations? If you have other questions, feel free to reach out or leave comments below. We're happy to help, and we're happy to help you unpack all of these new changes to the law. Take care.